Friends, in the history of India, the city of Delhi occupied a very important place and played an historical role. I do not wish and propose to give a detailed history of city of Delhi. When it was taken by, who built it, who ruled it, are all not important for the purpose of today's topic. But before independence, that is in the middle of 19th, up to middle of 19th century, Delhi was the capital of Mughal dynasty. After Sipai Mutiny in 1857, the Britishers waged a war against the last emperor of Mughal dynasty, defeated him and occupied the city of Delhi. Since then, it was in the occupation of Britishers till we got independence in 1947. After occupying the city of Delhi, the Britishers shifted their capital from Kolkata to Delhi in 1911. From 1911, for the administration of Delhi city, the British government appointed an officer called Chief Commissioner of Delhi. This officer was looking after the administration of Delhi. After independence in 1947, the government of India continued Delhi as the capital of Union Government of India. The Government of India in 1956 reorganized the states. In this process, the city of Delhi was declared as Union Territory. In this Union Territory, a Lieutenant Governor was appointed by the Government of India for the administration of city of Delhi. Later, in 1991, the Government of India amended the Indian Constitution, incorporated a new article, that is Article 239, capital A, and renamed the city of Delhi as National Capital Territory of Delhi. This is another stage of development which we see in the post-independent India. Under Article 299, capital AA, first important thing that we have to notice, this article specifies that the people of Delhi can elect a legislative assembly. That legislative assembly is having the jurisdiction like any other state in all the matters specified in list 2 of the Constitution and also in list 3 of the Constitution. List 2 specifies the subjects on which the state government is having the jurisdiction. List 3 specifies the concurrent list where the central government and state government both have jurisdiction to enact laws. This is what Article 239 capital A specifies. Another important thing that we have to notice in this article is exception is created. Security of people, police and land relations are all retained by the union government. Remaining in all other aspects, the state government is having the jurisdiction like any other state government. This is the important development that we see in 1991 amendment to the Constitution by incorporating Article 239 AA. Here we have to notice one important thing. That is, as I told you, central government and also the state government is having the jurisdiction and power to enact legislation on the subjects specified in concurrent list. In such a situation, if there is a conflict between the law enacted by the central government and the law enacted by the state government, in such a conflicting situation, the Supreme Court ruled that it is the central law that prevails over the state law. This clarification that I am giving insofar as concurrent list subjects are concerned. Because of this amendment, in 1991, state legislature was elected and there was no conflict, there was no much differences between the government of Delhi and the union government till 2015. Though there were certain small differences, they were all thrashed, solved, and they did not become prominent, they did not become a legal impediment for the proper and regular governance and administration of city of Delhi between 1991 and 2015. 2015. In 2015, a peculiar situation arose. In Delhi, the capital of India, BJP political party came to the power and occupied the union government. At the same time, in Delhi, the state legislature was under the control of Aam Aadmi Party, AAP. Between the union government and the state government, the conflicting interests were growing day by day between BJP and AAP. In such a situation, in 2015, the union government issued an ordinance. This ordinance is important for the purpose of today's discussion. This ordinance empowers the Lieutenant Governor of Delhi to have ultimate control on the services, appointment officers, transfer of officers, promotion of officers, demotion of officers, suspension of officers, dismissal of officers, like this, on all the service conditions of Delhi employees came to be vested with the Lieutenant Governor and not the elected governor. This ordinance became the starting point of the conflict between Union government and Delhi government. The Delhi government, being aggrieved by the ordinance issued by the Union government in 2015, started a legal battle. The Delhi government questioned this 2015 ordinance before the Delhi High Court. In 2017, the Delhi High Court gave a judgment upholding the legal validity of ordinance issued by the Union government in 2015. Aggrieved by the judgment of Delhi High Court, the Delhi government, that is the AAP government, carried the matter to the Supreme Court of India. The Supreme Court of India, a division bench, then a full bench, finally the constitutional bench consisting of 5 judges, presided by the Chief Justice of India, heard the matter. Finally, on May 11th, 2023, the Supreme Court delivered its judgment stating that the ordinance issued by the Union government in 2015 is not legal and is not constitutional. They quashed it. Further, the Supreme Court declared that under Article 239, capital A, the state government is having all the powers insofar as the administration of the Delhi territory, including the services and other areas specified in list 2 and specified in concurrent list. This is the judgment delivered by the Supreme Court. It also clarified and confirmed the exception given under Article 233 AA, that is the security, the police and the RAND relationship continue to remain in the hands of Union government. This is how the state government of Delhi succeeded in its legal battle before the Supreme Court, and the Union government suffered a defeat. When the matter stood at that stage, now the question comes, the Union government, within 1 week from the date of the judgment of the Supreme Court, issued another ordinance on 19th May 2023. This ordinance is the subject of discussion today all over the country. This ordinance specifies that in the matter of services in the territory of Delhi, a committee is responsible. A committee is accountable. The committee is empowered for all matters relating to services in Delhi territory. This committee consists of 2 senior officers appointed by Union Government of India and the Chief Minister of Delhi. This ordinance further specifies the majority opinion of the committee shall be the rule, shall be the law, shall be implemented. Now, this is the one, this ordinance, this committee is the question that is before the national debate. Surrounding this debate, political activity has commenced. Political parties are reorganizing. I don't want to go into the unity of the political parties, reorganization of political parties, and opinion of political parties on this issue. As a student of law, I have to make a submission before you that the ordinance issued by the Union government in May 2023 is with an intention to nullify the judgment of Supreme Court given in 2023 May 11th. This is unacceptable. This shows that Union government has no respect for the judiciary in the country. We all know for the last several years, we are seeing that Union government is making attempt after attempt to gain control over the Indian judiciary. In the matter of appointment of judges, promotion of judges, transfer of judges, the attitude of the Union government is a reflection that they have to gain control over the judiciary. You have also seen that judges, on the basis of quid pro quo, gave appointments after their retirement. It is not on the basis of merit. It is not on the basis of seniority. It is not on the basis of any recommendations by the Supreme Court. Pure on political measure, political interest, the post-retirement of judge is being decided. We have also seen the statement made by the Vice President of India and the former Union Law Minister. Time and again, their statements undermine majesty and dignity of independence of judiciary. Now, this ordinance is an attempt in this direction, disrespecting the Indian judiciary, and the intention is to nullify the judgment of the Supreme Court, which was in favor of the Delhi government. Therefore, looking either legally or morally, this is unacceptable. Second, when Parliament session is going on, the matter should have been brought before the Parliament. Where was the need for promulgating an ordinance? Again, without bringing the issue before the Parliament, the Union government committed a mistake in issuing an ordinance, and this is again against to several landmark judgments given by the Supreme Court. Third thing is, without amending Article 239AA, the present ordinance is issued. Article 239AA provides for election of a state legislature. The state legislature is empowered with laying the law, governing, embracing the programs, and planning everything as per Schedule 2 and Schedule 3. A list 1, a list 2 and list 3. Again, the present ordinance is contrary to the constitutional provision of Article 399AA, and this is unacceptable. Another important thing is, when there is a state legislature, what is the purpose of the state legislature? How do you bypass the state legislature? Bypassing the state legislature, constituting a committee, and that committee is empowered with the power to deal with the service conditions of the employees in the working under the union territory. No. Bypassing the state legislature and creating a extra constitutional body called under the ordinance in 2023 is undemocratic. This is unacceptable. Another important thing that we have to see in this development is, for the last several years, in several states, we are seeing how the federal structure is being dismantled. Economic power is concentrating in the hands of union government. Political power is concentrating in the union government. State legislatures are bypassed. All these developments reflects that the present union government has no belief in the federal structure of India. If federal structure of India is demolished, then there will be no India. This I have made it clear several times. Governors in some of the states are acting as political party agents of union government. That we have seen in Kerala, Tamil Nadu, Telangana, West Bengal, and many other states in the country. This is how the very federal structure, which is one of the basic features of the Indian Constitution, is being dismantled. The present ordinance is an attempt in this direction. Therefore, looking from any angle, the present ordinance is unsustainable in law. It is unconstitutional, undemocratic, anti-judiciary, anti-federalism. This is unacceptable. This should not be allowed to go. This is the time where the parliamentarians express their wisdom, come together, defeat the ordinance when it is presented before the parliament. I am hope and confident that if this ordinance is challenged before the court of law, it will not stand the scrutiny of judiciary. I am of the opinion that the union government will suffer a miserable defeat before the court of law if this ordinance is challenged. I hope that the government of Delhi will definitely challenge this before the Supreme Court of India. Further, what happened to Delhi in today's ordinance may happen to any other state government tomorrow. Why only in Delhi? They can extend it to any state in the country. In such a situation, the very principles of democracy on which we have built this country and the institutions that we have built the rights that we have given, the reforms that we have brought will all be ruined. Therefore, this is the time where the country, as one voice, the people of this country protest against this ordinance and save the constitution, save the democracy, and save the independence of judiciary, and save the federal structure of India. With these words, I conclude, and I thank Vinay Kumar and all his friends for providing this great opportunity to me to share few thoughts on the recent development of the ordinance issued by the Union government on 19th May 2023 relating to the service conditions in the territory of Delhi.